interactive session. So I'll keep the discussion on my end shorter so I can hear more from you out there who is listening, particularly the influencers, because I know there are challenges that you face that we might not understand from a legal perspective or from the perspective of those of us who are not in the field of influence marketing. So to thank the PDPO for this synchronization to bring these two worlds together is something that I'm very proud of. So I'll be sharing my screen in a few moments. Anissa, can you see my screen?
Yes, I can.
Okay, so the outline for our discussion today, we'll have an introduction into the topic. We'll define key terms that will enable us to have this conversation. We'll look at whether or not the Data Protection and Privacy Act and the regulations are applicable to influencers or applicable in the field of influence marketing. We'll look at the role an influencer plays within the data protection and privacy cycle. We'll also look at what's important for you to know to move out of this discussion that we're going to have. And as I stated, we'll also look at compliance, what you need to do to remain compliant with the PDPO, which is the Personal Data Protection Office, which is the host of this event. And then we'll also look at way forward, what next, after you know what to do, how do you go about it? And then the very interesting part, which will be the challenges, because the law is new and influence marketing is probably not something that we envisage to take such a big bomb at this time. So it would be interesting to know what are those challenges that you're facing, particularly because influencers are individuals. They could be you or me. They are not entities or organizations that set out to collect data, but because they have a large platform and brands would like to, work with them to run campaigns to benefit from the people they influence to market their products. They then fall into the ambit of how do we go about complying with this legislation around protecting people's personal data. So as by way of introduction, data privacy just really defines who can access data, whereas protection refers to the tools and the policies that you can use to restrict access to that data. In Uganda, data protection and privacy is legislated by the Data Protection and Privacy Act, which was passed in 2019, and the regulations were passed in 2022. These two form the legal framework for which Uganda seeks to protect personal data. And outside of this, of course, is borrowing from best practice in other jurisdictions, particularly the GDPR, which is the General Data Protection Regulations from the European Union. So what is influence marketing? We probably know a bit of it. And from the examples, I wanted to use pictures of some of the people you might know. One being the biggest, the person who has the most followers in the world, that's Cristiano Ronaldo. At least people from the football world know him. And then from Uganda, we have Manuela Mulondo. I chose her because I know she's running a campaign for Prudential, so I hope that can hit home. And then you have Uncle Mo, who you've seen do campaigns, excuse me, with KFC and other people. So I hope you can relate to those. But influence marketing is really leveraging the platforms that these people have in order to market certain products, because those products appeal more coming from the people who appeal to us. So it's easier for you to make a collaboration with Uncle Mo because we relate to Uncle Mo. We may not exactly relate to a big marketing firm. So, and these people are able to do that because of social media. They have platforms either on TikTok or YouTube or Instagram or Twitter. So that is the bits and piece of influence marketing. Now, key terms. When we talk about data protection, we're not talking about data in general. We're talking about personal data. And what personal data is, that information about a person that can enable them to be identified. That you can identify me as me because you know my name, you know I'm called Bonita Mlelenji. And perhaps if you have something like my national ID, you will know my date of birth. You will know the village. for registration, in as much as, depending, because we registered for the IDs from different locations, but ordinarily that should be your village. So when you look at my national ID, you have my name and you can identify me as me. You can identify me by my date of birth, perhaps. You can identify me by my NIN number, because that unique number is attached to my name. That unique number is also the number that is used to register for my SIM card on whatever network that you use. But when you have my NIN number, you probably also have my driving license. You probably also have my passport, which has my personal details. So personal data really is information about a person from which the person can be identified, that is recorded in any form, and includes data that relates to the nationality. So your national ID will say you're Ugandan. It will have your age. Marital status could be on another sort of document. It could be a marital certificate, or it could even be on your CV. Educational level could also be on your CV. You could have your academic credentials, your transcripts from the universities or whatever schools you went to. It could be a symbol that is particularly attributed to you, for which you can identify. For this one, because we're talking about influence marketing, and I hope this can cross over. When Prince, the artist, there's a time he changed his name from Prince to a symbol. But to date, people still relate that symbol to identify Prince, that when you see that kind of guitar, it references Prince. Well, I'll move on to the next definition, which is a data collector. A data collector means a person who collects data. Now, anyone can fall in this category. You ask someone for their phone number. You ask them for maybe where they live. You ask them for their full names. You then become a data collector. Now, we'll talk about how the role, the identification of influencers within, the data ecosystem. But for now, I'll just go through the definitions. Then a controller is really a person either alone who determines the purpose or the manner in which the personal data is to be used. Is it being used for the Prudential campaign? Is it being used for a KFC campaign? Is it going to be used for a Mother's Day campaign, for a spa treatment? Because I have this data, I then determine what I'm going to use it for. A data processor is a person who processes data on behalf of another. We'll look at processing in detail as we move along. And then a data subject. A data subject can be me or you, really an individual from whom, in respect of whom personal information has been requested, collected, collated, processed, or stored. And then consent, which is one of the very big terms that we're going to be, talking about, or referencing, saying this is the pinnacle of data protection and privacy. It means any freely given, specific, informed, and unambiguous indication of the data subject's wish, which he or she, by a statement or by a clear affirmative action, signifies agreement to the collection or processing of personal data. If you've had the opportunity of watching, there's a little video on YouTube that discusses consent. It's in a different aspect, because I think it's about sexual assault or sexual harassment, or within that kind of setting. But this video they use tea, say, do you want tea? Yes or no? So you have to affirmatively say, yes, I want tea. Someone who's drunk or someone who has passed out does not want tea. If someone says maybe, then they probably do not want tea, don't offer them tea. So the consent should be affirmative and should be specific and unambiguous, that yes, not maybe, yes, that is what consent is. So this other section is repeated. Let's kindly ignore that. And we'll move on straight to applicability. So I am an influencer. I'm just one individual. How different am I from the next person on the street? And why does this act even apply to me? I thought this act applies to entities, the MTNs or the Airtels of this world. But in the applicability section of the law, it specifically says that the act applies to a person. Now, a person can be a natural or an unnatural person. So the act applies to a person or a body that, one, collects, processes, holds, or uses personal data within Uganda. So I could be, me in Uganda, collecting people's personal data can be, I fall under the realm of the Data Protection and Privacy Act. But also because we have other people outside Uganda who process or collect personal data of Ugandans, this act also applies to them because you're collecting information that belongs to the citizens of Uganda, and that act will still apply to them. So you might have influencers who are based in Uganda or based in Dubai. If the influencer based in Dubai is still marketing or collecting or storing or processing data in relation to citizens in Uganda, this act would still apply to them. So identifying your role within the data protection and privacy ecosystem. Are you a collector? Are you a controller? Are you a processor? Are you a subject? So as we said, a data collector is the person who really collects the data. How can an influencer become a data collector? You might be running a campaign, say a Mother's Day campaign, and you say, you know, if you do ABCD, say if you post or you retweet and you get maybe 1,000 retweets from that, you will win. You'll stand a chance to win a Mother's Day treatment for you and your mother, or you and your sister, or whoever. And then you follow up and say, well, when you get the winner, you then ask, can I have your personal details? Okay, because you want to reward them, as you have stated. So you might be in that process, you are collecting their data. In the alternative, there are people who use cookies. Now, this might probably be for more advanced influencer platforms. You use cookies or tracking pixels that when users visit your page, when they look at certain particular items on your page, someone is able to sit down and analyze that data and say, okay, when people visit Cristiano Ronaldo's page, the thing they look at most maybe is shoes. Then you'll be able to know we should do a marketing campaign with Cristiano, or he can say, this is what is working on my platform right now. So when he is engaged by a third party, because you have cookies, which are little files that track your behaviors on the internet, or you know, if you have a link that leads to another landing page, say, you know, where the content creator, the influencer has put their items for sale, they'll be able to know that when people visit my page, this is the item they look for the most. In that way, you're still collecting their data because they leave a digital footprint that you are collecting. And then the social media platforms themselves collect data from you. If, say, you have, I don't know, 10,000 million or 10 million followers, and there are people who keep coming to your page or people who keep following you, your followers' data is collected from them following you. So you then have the social media platforms themselves collecting data that is collected by you. In that sense, you are somewhat a data collector. And controller, really the question to ask is, do you determine the purpose for which the data is to be? Do you determine what happens to the data? If you do have that power to determine, then definitely you become a data controller. Think of it as being some kind of king who decides, you know, what are we going to have for breakfast, or what are we going to do with this particular thing? You then, in that circumstance, become a data controller. And a processor, specifically processing, includes organizing, adapting, altering, using, or destroying this data. Are you putting it in a certain format? Are you building, say, a database, which is organization? Are you then either alternating this data to use it for a particular thing because you want this data to make sense to you? For it to make sense to you, you must put it in a particular arrangement, which is really processing. So if you are a data processor, you'd probably be processing the data on behalf of a controller to say that my followers rather, these particular followers like these particular items. So then you have a database of those followers who like those particular items. Somewhat maybe kind of off, but a relatable example would be clothing stores, or people who run clothing stores. They'll know that, you know, these particular users like it when I have new stock. And so I keep a database for when I have new stock, I reach out to those particular followers of mine. Then a data subject, at the end of the day, you are also a data subject. You might be an influencer who also follows another influencer, but also these social media platforms are collecting data from you. So you as an individual still remain a data subject in relation to your own data. We'll move on to the next one. So out of the many things we're going to discuss today, and you know, the law, like I said, is quite new, and today we want to have a conversation instead of going into the legalese of everything. So marking out what is very important for us to take away from this discussion today. Like one, I say consent. Consent should be the thing that you sing every day when you're doing your campaigns, because you cannot collect or process personal data without the consent of a data subject. If you do that, it's unlawful and it's illegal, and you can be penalized, sued for it, or a complaint can be lodged against you, and you can, if found guilty, can be penalized for it. And like I mentioned earlier, the consent should be freely given, not coerced, not forced, not, you must do it. You must tell your users that if you want, you can do it. You can consent to it. And then you have to tell them the consequence to say, if you do not, consent to it, perhaps you will not be able to partake of this particular campaign, so that the user knows, if I give my data, this is what's going to happen to it. But that also comes with giving them certain information, which we'll look at it ahead of this discussion. So it must be freely given. It must be specific. I want your data to use it for the Mother's Day campaign. I do not expect as a data, as your follower, to find that you've used my data that I gave you to use for the Mother's Day campaign, you're using it in a different campaign. So if I'm collecting data at that particular moment for that specific thing, I must also tell it that specific thing. It must be informed. What are you going to do with this data? Where are you going to keep it? So I need to know all these questions. So that's why consent must be informed. I don't make a blind consent. I tell you, this is what's going to happen. Do you consent or not? So you check the box. It must be unambiguous. Like I said, it's not maybe, it's yes or no. And then it must be clear. It's a clear affirmative action. If you check the box, ordinarily you must read the terms and conditions, you must read the privacy policy, but most of us do not. However, if you go ahead and check that box, then you have given your clear affirmative action. So data, children's data or data relating to children and special data. When you're dealing with children, that consent should come from a parent or a guardian or someone who's authorized by law to give that data. But if you last year, when they passed the amendment to the Computer Misuse Act, there was a provision that strictly prohibited collection of data or using children's images, save with the consent of their parents. You might find yourself in a sticky situation where you're running a campaign and you go out and take some pictures and you upload these pictures, and they probably have, images of children, which an image is also, something that can identify someone by, and you probably did not very clear that in those circumstances, that if you're running a campaign, if we do ABCD, you've consented to that. But you need to be very careful when you're dealing with data relating to children. And then there's another category of data called special data. This is information that relates to religious or philosophical beliefs, political opinions, sexual life, financial information, and medical information. This you can only collect if you have consent of the data subject. Like I said, consent is everything. And or if it's required for the performance of a certain contractual obligation. So you have, for a legitimate activity. So for the performance of a required contractual obligation could be, say, financial information. You have won a prize and we need to send you mobile money. So we'll probably ask you for your not mobile money, we need to send you money. So we'll probably ask you for your bank account details so we can be able to do that. There you are collecting it in continuance of performance of a contract subject to receiving consent from the data subject. Then when we talk about privacy or privacy in general and privacy and collection, it's important to note that the right to privacy is a constitutional right. And the law, the Data Protection and Privacy Act, prohibits the collection of data in a manner that infringes on the privacy of the data subject. So whatever you do, do not infringe on the privacy of the data subject. And to have privacy, for you to not infringe on privacy, you go into the ambit of protection. What are you doing to protect that data? Again, for collection, you must lawfully collect and collect only what you need. If you do not need, if you're giving away a prize, say Mother's Day, and you're only giving it to one person and not including maybe sisters within that particular family, if you only need the winner and their mother's contacts or personal details. Do not ask for their sister's details. You don't need that clearly in that kind of situation. So do not collect more than you require. If you only require their number, do not ask for their name because you don't need their name. The more data you collect, the more you put yourself at risk for if there is a breach. You then lose a lot more, or there's a bigger repercussion from losing such kind of data. And then you only keep it for as long as it is necessary. When the campaign ends, surely delete it as soon as you can. And then if you're to, process it any further beyond that particular reason for which you collected it, it must be compatible within the purpose that you collected it for. When you collect this information, this personal data, you must ensure that it's up to date, it's complete, and it's accurate. And then before collecting, you have to give certain information to the data subject, which goes back to consent, because this is now a principle of data collection. So you tell them what it is that you're collecting, why you're collecting it, how long you're going to keep it, where you're going to keep it, who you might share it with, and then when you might be able to delete it and such other matters, so that they select, do I want to consent? Do I not want to consent? If you remember in 2021, I think it was 2021 or 2022, lockdown kind of blurs those years a little bit when WhatsApp updated their privacy policy. And there was an issue regarding sharing of that data of WhatsApp with Facebook. And it made a lot of headlines, and there were people who refused to accept, to agree to the updated privacy policy. Some people did not read that, but it's important for you to read, because now people who read noticed that WhatsApp was saying, following this update, will now be sharing data with, say, Facebook or these other platforms within the metaverse. But I'm probably not on Facebook. I don't want to share my information with Facebook. So I need to have an opt-out. I do not want you to share my data with ABCD. You can have my data for this use, but you cannot share it with those other people. To which maybe they will say, if we can't share it with those other people, this and this will happen. But there should always be that opt-out of, I don't want you to use my data for ABCD. I don't want you to process my data in a particular manner. Those are some of the things that we'll be discussing, which is under data subjects' rights. And I remember that, if you remember that time, there was a whole blowout on social media that WhatsApp had to revise their privacy notice and remove that particular provision. So those are some of the things that we need to pay attention to when, in influence marketing. More important to note are the core principles of data collection, which is accountability, which is something that I already mentioned. Again, tell me what you want, why you need it. If there's a breach, let me know about it. If you're changing something in the way that you're using my data, let me know about it. Be accountable to the data subject. The collection must be fair and lawful. Lawful really regards consent. Fair is, don't take more than you need, really. Or rather, do not do it in an arbitrary manner, because in collection of data, you must collect the data directly from the data subject. Don't go to the other person to give you, someone else's personal data, especially because you're in the field you're in a field that has a potential to commercialize this information. It might be somewhat slightly different from asking, and I'm not saying it's correct, from asking on a WhatsApp page, I need to do ABCD, who has a contact for this, who can share this person's contact. I still have some challenges with some of those issues, but now that is a peer-to-peer kind of sharing of data, which I think is also a challenge for the PDPO. But that's also something very interesting for you to note. Minimality, take only what you need. Do not take any more data than you require. And then also in terms of retention, keep it for only as long as you need it. When you're done with the purpose for which you need it for, do not collect it. The more information you store, the more you put yourself at risk if anything happens to it. Transparency also ties into accountability. Tell your followers this. If you visit my page, if you take part in this campaign, this and this will happen, so that your followers know exactly what might happen if they participate in a particular campaign, or if they follow you on a particular item or a particular campaign. The quality of information, it must be complete and accurate and up to date. And then security of information. What safeguard measures do you have in place to make sure that this data does not leak, to make sure that your phone probably does not end up in the wrong hands, and maybe all your platforms are easily open to whoever is around and can get in and get certain information and use it for whatever negative activity. And then other thing for you to know is that we have the Personal Data Protection Office, which is the office that's hosting this webinar, which is also the body that is charged with the implementation and enforcement of the Act. Now, the office is an independent office. It's established under NITAU, which is National Information Technology Authority of Uganda. And then some of its mandates or its duties is to promote, monitor, investigate, and report on observance of the right to privacy, ensure public awareness about the Act, which is why we're here. They have webinars on this, on data protection, to receive complaints and investigate them, and also punish the offenders, and to establish and maintain a data protection and privacy register. Then there's a key officer introduced by the Act called the Data Protection Officer. And this person really is charged with ensuring compliance of entities that collect data. And so part of the ensuring of compliance is making sure you're registered with the Data Protection Office, and you are adhering to the practices that are laid down under the Act, and also ensuring, and you're also the liaison officer between the PDPO and the entity under which you serve. Rights of a data subject. A data subject has the right to access their personal data. So a follower can say, I want to know what information you have about me. They have the right to do that. They have the right to say, do not process my data in a particular manner, or do not use, yes, I'm participating in this campaign, but do not use it for direct marketing. I'm just participating in this, but do not use it for direct marketing or things like that. And then you have a right to, the data subject also has a right to rectification, erasure, blocking, destruction of personal data. So, and you know, for erasure or destruction is also the right to forget that if I was your follower and you had some information of mine and I don't want to be your follower anymore, and I want you to remove whatever data you have about me, I have a right to ask the influencer to do that. A right to consent to the collection or processing of data. Again, consent should not be forced. You give consent and it must be informed. You provide information for which a data subject can then make an informed decision to consent. Then you need, what else you need to know is breach of the law. If you do not comply with the law, definitely you might be found in breach of the law, and there are punishments for this because they are offenses for certain derogations from the law, which are matters, say, not complying with the Act, or selling personal data, or using it, collecting personal data without the consent of the data subject. You under breach, yes, of the law, there's breach of the law, but then you can have instances where you have a security breach on your phone. You must inform the Personal Data Protection Office immediately as when that happens. Another interesting thing is cross-border transfers. As an influencer, you have followers from all over the world, and you may also be a Ugandan influencer based in a different country that also is dealing with personal data of Ugandans. So what you need to know about cross-border transfers of data is, again, consent is at the base of everything, and consent, which must be informed, or that the data subject is given that certain information before they can consent. So it's very clear to them that if you give your data, I'm probably going to store it on my phone, which on this platform, which platform that is in either in Norway or whatever jurisdiction. So for purposes of cross-border, I am transferring this data to another country whose servers are in another jurisdiction. And that alone can be cross-border transfer of data. So the cross-border transfer is not really in terms of where it is, it could also be in terms of where you're storing that information, or if you have your own servers for your website as an influencer, you still use servers you still use networks or servers that are based outside of Uganda. And so it's important for you to know, if you are transferring this data, inform the data subject, or if you are, and make sure that the countries to which you transfer to have similar legal protection legislation for the protection of that data. So compliance and way forward. Number one is something that actually I would like to hear from the PDPO, which I think is a challenge, but as the law states, you must register with the data protection officer. And then it would be important for you to keep up with the law. So attend these trainings as frequently as you can, so that you can learn what's new or understand the act further. And then have a privacy notice. This, I think, is also another area of contention, but it would be important for you to have a link in your bio and have a privacy notice. In your privacy notice, you're telling your followers what you collect, what you use it for, where you will keep it, if you transfer it, how they can reach out to rectify or request to exercise any of their rights as a data subject. And also, at the end of the privacy notices, to have that checkbox of consent, because you must seek consent from the data subject before you collect their data. So this notice should embody all the principles of data collection as we discussed previously. Report any security breaches to the PDPO, and whenever in doubt regarding any related matter, seek the guidance of the PDPO. I seek their guidance often and many times, and they always come through. So you can, DM them, send DM them on Twitter, or write to them, or reach them on any of their platforms. They are usually responsive, and rather than, do the wrong thing, find out how you can do the right thing. And then if it's an endorsement, if you're promoting a particular item on your platform, clearly disclose that it's an endorsement, and also disclose the role that you're playing in this regarding the data protection and privacy within that ecosystem. Related particularly to influence marketing, I know in other jurisdictions and some celebrities who have been sued for endorsing products for which they did not specifically state that they were endorsing those products. Unlike Uganda, some jurisdictions, the marketing ecosystem or the marketing industry is heavily regulated. And they have that, some of the things you must disclose. So if you go right now to any celebrity's website, rather social media platform, if they are endorsing something, you will see at the top of that particular video or picture, it will say ABCD in partnership with Nokia, in partnership with Mercedes, so that it's an endorsement. Now, in terms of data protection and privacy, is for your user to know, if you are endorsing this campaign, who is the person behind it? Who is collecting the data? Is it you, the person I follow, or is it the person for whom you are doing the marketing campaign? Now, as an influencer, it's important for you to indicate that, so that your followers know that it's not you, you're simply being the face of this product, but you're not the one collecting the information. Or if you are collecting the information, you're collecting it on behalf of, say, Mercedes or Nokia. Which leads me to the next point. If you're going to share or disclose personal data, again, let them know. If I collect your data, I might share it with the brands that I do business with. Now, another challenge would be that, the brands keep changing, and you sometimes, and I know that PDPO requests you to list the people with whom evolving. So how do you figure out, always bringing it up to the user and saying, oh, last time I was doing a campaign with Airtel, now I'm doing a campaign with KFC, now I'm doing a campaign with, I'm going to share this data with this particular people, but keeping up with that, or drafting your policy in a way that allows you to have that angle. And if there's any detriment change that is made, which you deem detrimental, is to also let your users know. And then require your entities or the people that you work with to have privacy notices, to share them, and also to indicate, so that you can also clearly indicate that I'm doing this campaign for, say, for Silk or for Intake, and Intake is the one who is collecting the data. So you must read and consent to the privacy policy, or you must read and choose if you consent to the privacy policy of Mutake. I'm not the one who's collecting information. I'm not the one who's going to use this information. So that way you extricate yourself from the situation, because you have, those engagements and to identify who you are. Are you a collector, processor, controller? And then I let your users know which of the three people you are. And if you're not in any situation, it's also to say, I am just a third party. It's these people doing ABCD. I will not in any way touch or store your data. Have secure passwords and restrict access to your platforms and your devices. I know also influencers like to go out and have a good time. That's how they make their money. Please be secure when you take your phones out, or when you put your passwords if you're in a bar, in a crowded place, because you've seen instances where influencers platforms have been hacked into, and part of that could be even the friends, the people you hang out with, knowing exactly how to get into your device and hacking your platform or selling your platform to another user. Because what makes you an influencer is the number of followers that you have. And if your followers are gone, you're not an influencer anymore. And you have to build from the ground up to get back to the number of users that you had. But if that happens to you a lot, it also ruins your relationship. People say, we can't work with this person because they somehow seek consent for cross-border transfer of data, and look out for those countries to which you transfer that data. Do they have commensurate legal provisions? If you do not know, ask the PDP, or they will let you know. Know the data subject's rights. So that one time when a follower writes to you and says, I want ABCD, don't say, I didn't know about that. No. Once you know that they have the right to do that, when they write to you, you will know the procedure to go through for them to be able to exercise that right or to enjoy that right. Know and organize your data so that you can minimize the risk. Know exactly what you collect, maybe perhaps where you keep it, so that you can reliably say, I do not collect NIN numbers. I only collect telephone numbers and the social media handles, or I only collect social media handles. I don't collect any other thing. But that if there's any allegation to say, oh, I gave you my NIN number, you say, no, look at where I keep my data. I don't have NIN numbers. Read third-party contracts to understand the data protection and privacy concerns that may be involved. You might get into a campaign with a third party who might have something, say, the info that you give us that you've collected from your followers, we shall sell this data. Now, selling of data is an offense, and you should not be caught off guard. So read those third-party contracts and understand what your role is, or also their privacy notices. Understand what they will do with this data, because you might be an accomplice to something you do not know. Maintain the confidentiality of the data that you collect, even with the people you hang out around with, your clout. Be very, very, very critical of them. Challenges. This, I would really like to hear more from you. One, I'm pretty sure everyone is thinking, that's too much English. How do I get all this, in my head, or how do I keep up? If necessary, you can also consult legal experts on that. You could ask the question, how can I prepare an appropriate privacy notice? Reach out to the experts in the field to be able to tailor privacy notices for you. Then also brands may find you difficult. That's definitely a thing that could happen, but the truth is that each person has an obligation under the law, and ignorance of the law is no defense. You cannot say I did not know, or, so you might lose brands, but also if you become so professional, the brands will start to respect you and know that we are dealing with an extraordinary person who has professionalized their platform and knows exactly what they're doing. They know the laws that surround them and govern them. How can I guarantee that the data collected is complete and up to date? Require that in your privacy notice. Then distinguish between data and personal data. So when you talk about data, we're not talking about the MBs we buy on our phones, or the information in general that we collect or that we have. Like, I have data on this particular person. When we talk about data here and now, what we're talking about is personal data. So be critical of that. Is the information you have, does it amount to personal data? If it does, then you know that you have a big obligation to protect it. The other challenge that the influence marketing ecosystem is highly informal. It's a gig economy. I'd mentioned that to, professionalize your platform. And then influencers are individuals and not entities. So there may be a challenge with registering as data protection officers or performing their roles, because you're probably the collector, you're also the data protection officer, because you're one person, you're everything, you are a one-person team. That could be quite challenging. I know there are so many other challenges, and I'd like to hear from you. But as I close, I just want to re-echo that at the core of data protection and privacy is consent and security. Be proactive and take the courage to professionalize your platform and have a privacy notice. Whenever in doubt, ask the PDPO or a legal expert and stay up to date with the Data Protection and Privacy Act and the regulations and other laws in general. Like I mentioned, the Computer Misuse Act would also be one of those legislations that it would be important for you to take note of, and there are others like the Electronic Signatures Act and the Electronic Transactions Act, but today's focus was on the Data Protection and the Privacy Act. So I'd like to hear more from you. We can go into our Q&A session.
Okay, thank you so much, Bonita. Thank you for the wonderful, informative and educative presentation. What has stood out for me basically is seeking consent and of course reading third-party contracts to understand what your role is. I will dive right into the questions. Okay, the first question is it sufficient to have the privacy notice only on the website? Over to you.
You can have the privacy, if you have a website, you can have the privacy notice on your website, but then have the link in your bio on your social media platform and indicate it clearly that followers should read the privacy notice. So when they click on the privacy notice, they probably land on your website, but have a link in your bio that will still take them back to where your privacy notice is.
Okay, thank you so much. The next question is, what happens to, for example, customers who take photos of workers, let's say in a supermarket, due to poor service, and before the owner of the photo knows he or she is running over social media? Where does this kind of action lie? I think they would like to know whether in this case someone has been breached or not.
That's usually a very interesting situation, and not only for data protection, but because it ties into different perspectives of other legislations and something known as image rights. But there's also, when you talk about image rights, is knowing that if you are out in the public, it's possible that your photograph might be taken by someone. Now, the difference is this person taking your photo to use it for a commercial campaign without your consent? Because to do that, you will need to seek the consent of that individual. But sometimes you'll find that someone will take a picture of you and you do not know, what it is, and you wake up the next day and you find yourself to be a meme. Someone recently took a picture of some military officers having lunch at KFC. I bet they did not consent to that, but that picture made rounds, and then there were memes that came out of that. So there's a legitimate expectation that when you're out in the public, someone might take your picture, but what are they using your picture for? When you talk about data protection and privacy, because you are collecting this information, you're probably going to use it. You don't collect just to keep, you collect to use it for a particular thing. You have to seek the consent. So if lately brands like jumping on whatever is happening, in the world, but I think for this particular one campaign, brands could not jump on it because that picture was taken after there had been a gruesome incident that had happened. But I would imagine if it was not a gruesome incident, it would be, you'd find brands coming up with very interesting and comic statements on, such a picture. That would be, a different situation. So it differs according to the situation, but if you're collecting the data, it means you're going to use it. Before you collect it, you must seek consent, otherwise you're collecting it illegally.
Yes, thank you very much. I'll move on to the next question. This is basically about retention of records. Someone is asking, banks are required by law to maintain records of a minimum of 10 years. So the part where you mentioned that data should be deleted after using it may not be possible. Kindly shed more light on this issue.
That is correct. So when I say that data that you're not using anymore should be deleted, that's a proactive, it's in reference to, or maybe I should restate, that you collect only what is necessary and you keep it for as long as is necessary. If you don't need it anymore, you have to get rid of it. I cannot imagine a situation where, say, you were running a campaign for Mother's Day. Mother's Day ended. Someone would not expect that beyond August, you should still have those records because Mother's Day ended. When it comes to banks, banks are regulated institutions. They're regulated by the Financial Institutions Act, but they also use this data for a long period of time. So by law, one, they are required to maintain records for 10 years after, or to maintain records for at least a period of 10 years. That's a requirement of them by law. But outside of that, they will still need to use this data. 20 years later, you have the same bank account. You go to that bank to get your statement. The bank will need your personal information to be able to do that. The longevity for which you keep the data or the duration of retention depends on the use of data. So keep data for only as long as is necessary. Where if it's not necessary for you to have info that you use for marketing campaign or for Mother's Day, get rid of it, move on to the next one. And the challenge now with the influencer, like I said, you are one individual who's using a phone that only has a password or a fingerprint or facial ID. You probably don't have other features protecting the information on your phone. It puts you at a risk as compared to banks that have big budgets for cybersecurity and they have a whole team of people and departments who are protecting that data. But the baseline is keep the data for as long as is necessary. When you're done with it, get rid of it, because that reduces the risk of breaching or you even losing data that you didn't even need in the first place.
Thank you so much, Bonita. I really hear you on that. I will go to the next question. There is an interesting question here. Someone is asking, how do we as an organization ensure that the content we give influencers are only used for the purpose that we intend the marketing to be?
Thank you. Have that have that in your privacy notice as an institution or a firm that who works, and also have that clearly in your terms of engagement with the influencer. So when you give them a contract, have that clause on data protection and say, if you say that, in the performance of this contract, you will collect personal information from your followers. This personal information should only be used for this campaign. So clear that out in your terms of engagement from the get-go, and also have that in your privacy policy that you share with the influencer.
Okay, thank you so much for that. There is another question which I want to believe is the last one. Someone is asking, how is verbal consent applicable in a court if this is acceptable? I do not know if you're able to get this question, Bonita, because...
Could you kindly repeat? I don't think I understood it.
How is verbal consent applicable in a court if this is acceptable? I think I will ask the person to unmute. I will unmute them and they ask it. Okay. All right. Another question here. Someone says, at my organization, we have consent forms that we require get signed by all partners at events we host. We also make it a point that we verbally notify all attendees that agreeing to pose for photos is considered consent for us to use those photos in social media campaigns. How do we ensure influencers use this content? Okay, this is just the same as the question you just answered. They are also asking about how they ensure that the content that they give influencers is only used for the intended purpose. Okay, one more last one. This is the last question. Should resolved breaches be reported as well? Over to you, Bonita.
There is, for all entities that collect, process, or control data under the law are required to send a report to the Personal Data Protection Office. And that report lists all, you report on whether there were any data breaches, if they were resolved, and all those other matters. So yes, even breaches that were resolved must be reported, but that reporting can come when you file your annual, it's called the annual compliance report. That reporting can come when you file the annual compliance report.
Yeah. Okay, thank you so much, Bonita. Thank you for answering all those questions. It has really been a great pleasure having you today, and we do look forward to hosting you again in future. I would like to thank everyone that has attended today's webinar. We host these webinars once every month, basically on the last Thursday of the month. So we encourage you to keep following us on our social media platforms to keep updated on when these webinars are going to be taking place. I have shared a link in the chat. Kindly click on that link and give us feedback. The feedback you give us will enable us to know how we can improve these trainings. Maybe there are a couple of questions that were really addressed to the office. Okay, someone said they are inquiring about their certificates. The certificates are running for 1 year, but they had paid for 5 years. Yes, currently the certificates run for a period of 1 year, but you have to renew every year. So what you're going to do is you're going to keep attaching the same proof of payment every year during your renewals. So I'll give us a few minutes to be able to click on the link and give feedback. I'll give about 3 minutes and then I'll close this webinar. Thank you so much for attending. Yeah, I can see the comments coming in about the presentation. The presentation will be shared and the link for this webinar is also available on our YouTube channel. Our YouTube channel is PDPO Uganda. Just go there and check the live recordings and you'll be able to access today's webinar. Bonita, your hand is raised. Would you like to say something?
Yes, Anita.
Okay.
Yes, just to thank the PDPO for this opportunity to share, and also for everyone who has attended. And I'm available to continue this discussion if you'd like to. I will share the final draft, the final copy rather of the presentation. I realize there's a part that's repeated. So Anita will rework this and send it back to you. And my details are there. You can reach me in case you need to continue this discussion. Thank you.
Okay, thank you so much, Bonita. We'll be waiting for that. And thank you for today.